My name is Jackie Ogden. I'm the Relationship Manager here in Queensland, and on screen with me is my wonderful colleague, Jennifer Sturgess, who's going to be giving this presentation. I'll be disappearing into the behind a screen of invisibility. I always did wish that was one of my superpowers. So tonight it will be. I'll be under the Zoom cloak of invisibility, but I'll be keeping an eye on the chat for Jen. So if you do have any questions throughout this presentation, please let us know. Well, Jen, I just want to be respectful of everyone's time this evening, so we might get started. And before we do hand over to Jen for her part of for her presentation, I'd just like to do a quick acknowledgement of country. So as we gather online for this presentation, we recognise that many of us are on different lands of different traditional custodians, and we would like to acknowledge all of the traditional custodians of the lands we are all present on today, and any Aboriginal and Torres Strait Islander people who are part of our audience today or watching the recording at a later date. We pay our respects to each of their elders, past, present and emerging. So thank you again for joining us this evening, and we welcome you for wherever you are across Australia. I'm going to hand over to my wonderful colleague, Jennifer Sturgess. So just a little bit about Jen before I do so. Jennifer Sturgess is a full-time lecturer at the College of Law based in Brisbane, as I am, and teaches across the entire practical legal training course. So anyone entering the College of Law Queensland course will potentially have Jen as a lecturer sometime in the future. So prior to joining the College of Law, Jennifer was a solicitor in private practice for almost 10 years, and during that time she acted primarily for solicitors in professional negligence claims. She has also spent 2 years working in-house for the Queensland Professional Indemnity Insurer. She's got lots of really valuable information to share with us tonight. So I'm going to disappear under a cloak of Zoom invisibility, and I will see you all at the end of the presentation and also in the chat. So take it away, Jen. Thank you.
Thank you, Jackie. And once again, welcome everybody to this discussion about risk management and how you might avoid reduce risk in practice. Why is that important? Well, it's important for a number of reasons. One, claims do cost your employer money if a claim was made against you. And if a claim is made against you, it's a very stressful thing for a solicitor to go through. The statistics are that a solicitor in practice will have, on average, 2 claims against them in their working life. Now, that doesn't mean that they will have 2 claims that are successful, but on average, they will have 2 claims. So I want to talk to you a little bit about where those claims are coming from, and more importantly, what you as young practitioners or practitioners in the future can do to try and lessen the risk of a claim being made against you. So firstly, where are the claims coming from? Don't think just because you're in a certain area of law that you're unlikely to have a claim against you. Claims arise really in all areas of law. However, if you look at the slide on the screen, you will see that primarily the most claims are in the areas that I've got up in the slide. So first and foremost, cottage or commercial conveyancing. Conveyancing is a source of a lot of claims. For example, in 2020 in Queensland, and I'm sure this would be similar no matter where you are in Australia, it accounted for 27% of all matters. So more than 1 in 4 claims related to conveyancing matters. Why? Well, of course, probably the main reason is there is a lot of conveyancing that goes on all over Australia. So there are a lot of matters, solicitors are involved in a lot of matters, so therefore there are a lot of claims. What sort of claims arise in conveyancing? Well, you know, all sorts of claims. For example, failing to notify the seller if you're acting for the buyer when finance has been approved, failing to read searches, there's all sorts of reasons claims might arise in conveyancing. Commercial litigation is another source of a lot of claims. In 2020 in Queensland, it accounted for 33% of all the damages paid out. So commercial litigation claims are a very large part of the claims that the professional indemnity insurer has to deal with. Personal injuries is another large area for claims. Often solicitors miss limitation periods, they settle claims too low. There's all sorts of reasons why claims appear in personal injuries matters. And then general litigation, wills and estates, and family law. They are all the source of claims. So no matter what area you're in, you will find that from time to time claims emerge. So just a slide here. What I want to talk to you about tonight, and which I think is probably will be most interesting to all of you, is how you might go about avoiding claims. So, what can you do? Here are some practical tips that hopefully you can take away with you, which will help you to avoid claims once you're in practice, or if you're in practice, things to think about now. Now, the first thing I've got up there is ensure you know what your client wants. Don't always assume that you know what your client wants to get out of a matter. For example, and I'm going to give you a few examples tonight. All of these are true and from various claims made against solicitors over the years. For example, in a family law matter, a solicitor was acting in a matter and he told me that he was acting for a father who had brought an action because he wanted his children to live with him and not his ex-wife. They went to court and lost. So he instructed his solicitor to file an appeal in the matter. The solicitor dutifully completed the notice of appeal, showed it to the client, and the client said, "Oh no, that's not what I want." The solicitor had put in the notice of appeal that the father wanted the children to live with him. The father did want that, but he also wanted the solicitor to include another claim in the notice of another point of appeal in the notice of appeal, that if the court determined that the children were not to live with him, that he be allowed to clone the children. Now, who would have thought that that's something the client wanted? Obviously, the solicitor said, "No, I'm not doing it." However, that's just probably a little bit of a strange example, but an example of you don't always know what the client actually wants. And going to court or negotiating something where not actually knowing what your client wants can leave you open to a claim. The second thing there I've got there is to record the retainer accurately. You should always know what you are being asked to do and what you're not being asked to do, because claims can arise. For example, this involved a leasing dispute. What happened in this particular case was a client had a lease and they had an option to extend the lease if they wanted to, but they had to exercise that option within a certain period of time. They claim that it was agreed between them and the solicitor. The solicitor would exercise the option. The solicitor thought that it was the client that was going to exercise the option. So neither party did. What happened then was, because they hadn't exercised the option within time, the landlord said, "Right, the lease is, you haven't exercised your option within time, the lease is going to be terminated." The clients weren't happy about that. They were running a Chinese restaurant there. And then they therefore had to move the entire Chinese restaurant, find another place. And that obviously cost them money, make good the premises they were leaving. And they sued the solicitor because both were at cross purposes. Each thought the other one was going to be exercising the option. The matter was litigated, but somewhat luckily for the solicitor and unluckily for the restaurant owner, they had been forced to move, but in fact, they were actually making a lot more money in the new premises than they were before. So that kind of wrecked their claim somewhat, but nevertheless, a claim emerged. Thirdly, I've got down there, give your client realistic advice. Don't guarantee a particular result, and always explain the range of outcomes that might be possible. Often solicitors tell a client early on, before they've had a chance to properly investigate it, that they're likely to get a certain outcome or receive a certain amount of money. When it turns out that perhaps after further investigation that's not going to be the case, clients don't always react well to that. And of course, a claim can result because you have not achieved what they, you have told them that you were in fact going to achieve in the litigation. Turning next to estimating fees accurately. Now, I've got there a couple of points which I think are very important. Firstly, explain to the client how fees will be charged. You usually have to give the client, if it's a litigated matter, an estimate of what your fees are going to be. You'll do that usually at the beginning of the action, but it's very important to review that estimate throughout the course of the litigation. And you should always advise the client promptly if your estimate changes. Now, you might think you should be aware that that's very important. Nobody likes to be quoted a price. For example, if you take your car to be serviced and then come back in the afternoon and without being told, you're charged another price. So that's it. Sometimes when solicitors don't tell clients that fees are being run up, they feel a bit like that. They feel that they weren't warned, they're blindsided, and they become very annoyed. For example, if you were expecting the fees to be $40,000 for a matter, that's what you got told at the beginning of the action, and then at the end of the action, you were handed a bill for $75,000, you wouldn't be very happy at all. Now, how do claims arise from this? When I was working at the professional indemnity insurer, we had a number of claims that arose as a result of clients not being kept informed about their fees. Once again, they were told that there would be a certain amount, only to receive a bill for a much larger amount. As you can imagine, the clients were very angry. Despite the fact that you did a very good job, or you have done a very good job, the clients will not be happy with you. What they will often do then is go off and see another solicitor. The other solicitor, and it's happened on a number of occasions, the other solicitor would write to the first solicitor, making some sort of complaint about, something in the file that wasn't done quite properly. It might be far-fetched, but it usually had the desired effect, which was to result in the solicitor reducing their fees in order to get rid of the matter and not have to worry about it any further. Often solicitors who'd done a pretty good job and earned every cent of those fees had to reduce their bill in order for them to make the matter go away. That all could be avoided, obviously, by estimating the fees and keeping the client informed if the fees changed. Another thing that you can do is to be aware of the dangerous client. There are some clients that no matter what you do will never be happy. And no matter how good a job you do, they will probably end up making some sort of claim or complaint against you. So how do you spot these dangerous clients? Well, a couple of things here. If someone has had a lot of previous solicitors and they tell you they've had a lot of previous solicitors, and these solicitors, according to them, have been no good, don't understand, hopeless, that gives you a pretty good idea that they are a difficult client that is very hard to please. Now, that may be legitimate, but it's something that should put you on notice, and you need to think to yourself, do I really want to act for this client? The next thing that you might have a dangerous client if they are the sort of person that refuses to pay a realistic fee. So you discuss with them perhaps, what you're going to charge, and they want to dispute it. They want to try and beat you down. They're not happy. They can't understand how it's going to cost that much. That might be the type of client to avoid, because when it comes time to paying your fee, they're probably not going to want to pay it. They have unrealistic expectations as to time frame and or result. So they want things done immediately, even though it's not necessary that they be done immediately. They've got a certain view about what the result is. And therefore, if you don't get that result, they're probably going to blame you, say that you're negligent, and potentially bring a claim against you. Some clients are very confrontational and argumentative. Once again, they think they know more than you, and they don't want to accept any advice you're giving them. Now, we give advice as solicitors, and it's up to the client as to whether or not they take it. Of course, no one's suggesting that a client, you shouldn't, the only clients you should have are clients that agree with you 100% and don't dispute anything you say. But if you do have a client, or you're looking at taking on a client who appears to want to argue with everything you say and accept none of your advice, then once again, that's a client that is probably more likely to bring a claim against you than perhaps one that's willing to listen to what you've got to say. So that is something else that you need to think very carefully about if you are taking on a client. You are probably, being junior lawyers, you're probably not going to be in a position to determine who should be a client and who should not. But often you will do, when you get into practice, perhaps a first interview, and the partner may ask you for your opinion as to, what you think about taking this client on. If you do suspect that the client may be difficult, you should definitely tell your supervisor, because you might be doing them a favour, because once again, they might be the sorts of people that will be intent on bringing a claim against you. And here's just a little cartoon about difficult clients. Okay. The next thing I want to talk to you all about is avoiding risky transactions. Don't become involved in transactions if you suspect that somebody is being pressured into that transaction. We're all aware of the cases that we've learned at law school, like Amadio, etc., and the dangers those sorts of situations pose. If you see, for example, someone coming into your office, perhaps a middle-aged man, dragging his elderly mother by the arm, plonking her down in a seat, putting a guarantee in front of you and saying, my mother's agreed to guarantee a loan that I'm taking out for, $200,000 from the bank for my, in order to fund my new business venture. So she just needs some legal advice. Give it to her, please, so I can get the guarantee back to the bank and I can get my money. That may be something that you don't want to get involved in, really, for obvious reasons. If you think someone is being pressured into something, it's something that you should stay away from. Similarly, be careful about getting involved in claims that involve a conflict of interest. So either a conflict of interest between clients or a conflict of interest between the client and yourself, the solicitor. Now, there are lots of situations in which we do act for both parties to a transaction. For example, if you're working in a small country town, you might be the only solicitor in town. So you might be acting for, say, in a conveyancing transaction, you might be acting for both the buyer and the seller. That's not that unusual, but just be aware that, in situations like that, if conflicts of interest do arise, you may have to stop acting for both parties. And certainly, if there is a conflict of interest between yourself and the client, that's certainly a situation in which you should not be acting. Okay. One thing you can do in order to avoid claims is think about specialising. Now, that's not for everybody. Some people really enjoy general practice, and that's absolutely fine. However, the statistics are that the majority of claims relate to or involve practitioners that are in more general practices. Now, once again, that's not to suggest because you're specialising, you can't get sued. Of course you can, but more claims arise against practitioners that are practicing in general practices as opposed to specialists. Well, why is that? Well, general practice is hard. You've got to have a lot of knowledge about a lot of different areas of law. And, for example, on any given day, if you're in a general practice, someone can come in, they might want you to act for them in relation to the purchase of a business. Someone might come in and want you to draw a will. Someone might have been injured in a personal injuries action. Someone might have been sacked from their job and want legal advice about that. There is any number of things. Someone might want to subdivide land and want some advice about that. There's so many different things you can be confronted with in private practice. It's hard to be on top of everything. So specialising is a good way of avoiding claims. You become highly skilled in one area and you can concentrate on that area, and therefore the chance of making a mistake is significantly less. I've also got there, don't be afraid to refer work away. When I was working at the professional indemnity insurer in Queensland, we had a case where we were involved because there was some professional negligence claims that arose out of it. But he'd been in specialising in one particular area of law and for a number of years, and he decided he wanted to go into practice on his own. So he set up his firm in the suburbs, and before long he started to get a lot of work, and it was all different types of work that he wasn't familiar with, but starting on, he thought he should take on everything. Anyway, a lot of the work that he had taken on, he just simply didn't have the skill to do. So things started going wrong. Clients started ringing him up. He didn't have the answers, so he started avoiding the clients. He wasn't returning their calls, wasn't, returning emails and things like that. One particular client that had been trying to get on to him for a number of weeks without success decided that he was going to confront him at his office. And this particular solicitor rode a motorbike. So the client waited outside of the office. As I said, it was in the suburbs, until he saw the solicitor riding up on his motorbike. The solicitor gets off his motorbike, comes around the front, walks through the front door and into his office. So the client quickly gets out of his car, runs across the road and comes into the office. And he says to the receptionist, "I want to speak to the solicitor." And the receptionist, with a guilty look, said, "Well, he's not here." And he said, "That's a lie. I've just seen him arrive. I want to talk to him. I'm not getting any response and my matter's going nowhere." And with that, he heard the back door of the office opening and closing. He then heard the motorbike start off, and he saw ran outside to see the solicitor driving up the road on this motorbike to get away from him. What ultimately happened in that matter is the Law Society in Queensland came in and actually took control of the entire practice and then farmed files out to other solicitors. And of course, there were quite a few claims that resulted in that, because he didn't know what to do with all these matters. So he sat on them, he missed limitation periods, etc. So don't feel as a young practitioner you've got to take on work that you really don't know anything about. Don't be afraid to refer work away. And then finally, I've got there, put your hand up if you are out of your depth. That's really important. Sometimes people feel that they can't do that when they're young practitioners. They feel that they should know everything. The fact is, you don't know everything. And it's much more, and sometimes it's hard when you've got your first job and you don't really want to admit that you don't know what you're doing. Better that than have a claim against you because you've just sat on it and done nothing, or in fact made the wrong decision. Most people in firms are perfectly willing to help a young practitioner if they put their hand up and they say, "I'm out of my depth, I don't know what I'm doing." So I think you should always do that. Sitting on a file because you don't know what to do and not asking for help is the worst possible thing, because sooner or later, your supervisor, the partner you're working for, is going to become aware that there's a problem with the file, and you're going to be in much more trouble than you would be if you simply put your hand up and asked for help. So go to other people in the firm. Sometimes I used to find, as a young practitioner, we used to brief counsel a lot. Certain counsel a lot, and I used to find that if I was having a particular problem with a file or I wasn't too sure, I would ring up that barrister and I'd go, "Could I run something past you?" And 99% of the time they'd say, "Yes, of course, no problem." And that would perhaps put your mind at ease or reaffirm what you were already thinking. But don't sit on things. Things don't get better by just sticking them in a drawer and forgetting about them. Okay. Now, look, if you forget everything that I've said this evening, you can, well, I prefer you remember all of it, but if you forget everything, please remember this. This is probably one of the most important things. And you might think to yourself, what I'm going to tell you is fairly obvious, but trust me when I tell you, a lot of solicitors do not do it. And that is take file notes of conversations with clients. It is very important that you do that. Why is it important? Well, it's important because if there's a dispute between yourself and the client, so let's say by way of example, the client says, you didn't advise me about a limitation date, and now I can't bring my claim. And you say, yes, I did advise you about the limitation date. And the client says, oh, no, you didn't, and brings a claim against you. The chances are that if there is no file note or no record of you, written record of you having given that advice, the chances are that the judge will believe the client as opposed to you, the solicitor. Now, why do I say that? Why should the client why is it more likely that the client would be believed over the solicitor? Well, there's two really important reasons as to why. The first one is that giving a client advice about a limitation date is important advice. And the way the judge sort of thinks about it is that it's important advice, and if that advice was given, a prudent solicitor would have made a note of it. The fact that there is no note of it indicates to them that the advice wasn't in fact given. The second reason that they would probably conclude that you hadn't given the advice is because when a client brings a claim against you, in Queensland, a client has 6 years to bring a claim against a solicitor, and I imagine it's pretty much the same in all the rest of the states. They only have to commence the proceedings within 6 years. They then have another year to serve the solicitor. So you might make an error today, and then you might not actually be sued or know anything about a claim for, say, 7 years. And once again, I'm sure that's a fairly standard across all of the states in Australia. So if that was the case, that solicitor, when the judge is thinking about it, he or she is going to think the solicitor perhaps had one conversation, which is the basis for the claim with that client 7 years ago. But since then, let's say it is a conveyancing matter or something like that, or a personal injuries matter, they've probably acted for hundreds of clients and had thousands of similar conversations. That client who is bringing the claim has probably had one conversation with one solicitor, being you, in the past 7 years. Who's going to have the better memory about what was actually said during the course of that conversation? Is it you, or is it the client that's had one interaction with one solicitor and one discussion? They're probably going to conclude that it's the client that's got the better memory of that conversation. So always make sure that when you talk to a client, you pick up a pen and you start making file notes. You don't have to make file notes of everything that is said word for word, but certainly you have to make notes of the important parts of the conversation. So if a client's giving you instructions, you need to note those down. If you're giving the client advice, for example, about a limitation period, you need to make a note of that. So if the client turns around and says, in years to come, you didn't give me that advice, you can produce the file note as evidence of that, in fact, you did give that advice. I was involved in 2 cases a number of years ago where, in one case where the solicitor did in fact take file notes, and in another case where the solicitor didn't. And in the case where the solicitor didn't take file notes, he was lucky enough to be successful at trial, but the only reason he was successful at trial was because of the fact that the plaintiff came across as rather shifty and dishonest. He nevertheless had to go through an entire trial, an entire case, and he himself said, if I had only written a file note, this probably could have all have been avoided. And I think that's right. What happened in that case is a plaintiff, he was a youngish man, early 30s, he was injured, he badly injured his back at work. And he probably would have had a great deal of difficulty ever working again. He brought a claim against work cover, we call that workers' compensation against the against his employer, and it was handled by their insurer, Work Cover. The matter had been going on for a while, and Work Cover made an offer to settle via his solicitor. The solicitor rang the client and said there's been an offer to settle of, I don't know, $300 or $400. It was a significant amount. The solicitor said there's been this offer, and this was all verbal, there's been this offer. I don't think you should accept it. I think it's too low. You'll probably never work again. I think you're entitled to more. The client said, let me go away and think about it, talk about it with my wife. I'll come back to you. He went away, came back a short time later, rang up the solicitor and said, I want to accept the offer. The solicitor said to him, once again, it's up to you, but I would recommend that you reject the offer. I think they've got more money and we can get more out of them. The client said, thanks for the advice, but no thanks. It's coming up to Christmas. We've got no money. We want to buy presents for our children. So please go ahead and accept the offer. The solicitor made no notes of these conversations at all. So he went back to Work Cover. He accepted the offer on behalf of the client. Anyway, in time, the money was paid. The solicitor's parents-in-law lived across the road from the plaintiff, and they reported that after the matter was settled, a new car arrived, a new boat arrived, which he's perfectly entitled to buy. But he spent up big, and about 2 years later, the solicitor was served with proceedings, and the allegation was that the solicitor undersettled the claim. The solicitor said, yes, I did undersettle the claim, but I did it on your instructions. And the client said, you never gave me that advice that the claim was worth more money. Of course, the solicitor said, yes, I did. And the client said, no, you didn't. The problem was, of course, there were no file notes whatsoever. And as a result of that, the solicitor went to court. And as I said, he was extremely lucky. The judge found that he just did not believe what the plaintiff had to say. The solicitor told me at the time that that the plaintiff had told him that before he was going to medical appointments, he was carrying bricks round. He was putting them all in a wheelbarrow and carrying them around to put his back into spasm to make it seem worse than it was. So he was a little bit on the shifty side. He certainly had a back injury, but in light of the evidence that the plaintiff gave, the judge was prepared to accept the solicitor's evidence that in fact he had given him that advice. But as he said, all of that could have been avoided if he simply kept file notes. And I would suggest, which brings me to that that final point there, that in some instances, a file note is not enough. You should back up. The verbal advice should be backed up by written advice. From time to time, clients will go against your advice. They won't accept your advice. They'll want to do something different. That's perfectly fine. It's ultimately their decision. However, if a client is doing something that you think is detrimental to them, to themselves, I think it's always good practice to put in writing your advice to the client, to also put in writing the fact that you, the solicitor, have been instructed to, for example, accept an offer, and you will only do so when the client signs the letter acknowledging that he or she have received this, this advice that, that they shouldn't accept the offer. That way you are protected. And you will find that, it'll be much harder for a client to sue you. As I said, I was involved in another case too. This particular case, there was a file note. That solicitor was sued about, I think, about 4 or 5 years after he first came to see the solicitor. What happened in that case was he came to see a solicitor in Townsville. He was an electrician that worked in the mines out at Mount Isa and in the underground mines. The underground mines, of course, are very, the floor is very uneven in underground mines, as you can imagine. And he had gotten up on a step ladder. So it was a short ladder in order to reach up and do something. The ladder toppled over. He fell off. He landed on his heel and he badly injured his heel. The solicitor suspected that his wife wanted him to come and see him. So he came, he gave the solicitor some basic instructions of how the accident happened. The solicitor actually in his file note drew a stick figure on a ladder to remind himself of what happened. He says that he asked the client some questions about whether there was a taller ladder or something else he could have done in order to get up to reach whatever he wanted to reach. The client said that he didn't know. So the solicitor said he would need, the client would need to go back and find that out. And he also said that he told the client that he had 3 years to bring a claim. And if he wanted to bring a claim, he should come back and see him. This also was, when the client came to see him, he charged him $20. So it was pretty much a pro bono consultation. He never saw the client again, except for about, he heard nothing further from him for about 3 or 4 years when he got a phone call from the client saying, "What's happening with my claim?" The solicitor said, "What do you mean?" And he said, "You were supposed to, be handling that claim." And the solicitor said, "No, I wasn't. I told you that you were to go away and look at find out some things. And if you wanted to pursue it, to come back and see me." And anyway, the limitation period's expired. And the client said, "Well, you never told me there was a limitation period." The solicitor said, "Yes, I did." The client said, "No, you didn't." And of course, there was, ultimately, he sued the solicitor for failing to commence proceedings on his behalf. At the trial, the solicitor was able to, despite the fact it was many years later, they were able to produce the file note of the entire meeting in which there was a note that he advised him of the limitation period. That, together with the plaintiff's evidence, resulted in a victory for the solicitor. Clients, when they're bringing claims against you, are often very certain of things. They say that they've got, a memory of what happened on that particular day that the alleged negligence occurred, and they've got a very accurate memory. In this particular case, the plaintiff was cross-examined about what he recalled, and a couple of the questions the barrister asked was, "What does my client look like? What does the solicitor look like?" The solicitor had the brightest, reddest hair you've ever seen. So the barrister wanted to test out how good a recollection he had of the meeting. And he said, "What does my client look like? What colour is my client's hair?" And of course, he said something like brown, where of course it wasn't. It was bright red. He asked him where the solicitor's office was. It was actually up above a bank, up a very winding set of stairs. He said it was on the ground floor. So he clearly had no recollection of the meeting that particular day. But he was very lucky. Despite only seeing the client once, he was able to produce the file note. And that was a big part in him avoiding that particular claim.
Excuse me, Jen, can I just interject with a question from the audience? Is that all right? Olivia has been loving all the stories that you're sharing with us, and she wants to know, going back to the client with the back injury who would never work again. So she's asked, what recourse is there, as with this client who allegedly would never be able to work again? due to a bad back injury. He received his payout, buys a new car and boat, obviously speaks with others over the years and makes the decision that the solicitor did not get him the highest offer. Yes, understand that there was no file note, however. Is there not suspicion in this matter? And if so, what does the solicitor do? Do they report this client to work cover? What is the correct procedure here?
Well, no, because what he's alleging is it was the solicitor's fault. So he's not really the offer was made by work cover. He accepted it. He's saying that I didn't accept it because of the fact that you did. I did accept it because you didn't give me the correct advice. It's your fault. So it's really got nothing to do with work cover, because once the offer is accepted by work cover, because that's the thing, when you're giving clients advice, and let's say they want to recover money from an insurer or something like that, it's once and for all. You only get sort of one bite of the cherry, so that's why it's important to give the correct advice. And the solicitor says he gave the correct advice in this situation, and it was rejected. So yes, and of course he got the payout. He's entitled to do with it whatever he likes, but the solicitor suspects that he ran out of money. And the solicitor said he was a very nice fellow, and he said, well, maybe he just forgot that he got that advice, and maybe he did. So that's quite possible that he forgot, but the solicitor was unable to prove through a file note that he did in fact give him that advice, and he acknowledged that. And he was an experienced solicitor, and that's why I raise this here. Sometimes people think, oh, that's obvious. Trust me, it's not always obvious. People get busy, they forget to write file notes, and if unfortunately you've got perhaps someone who genuinely thinks you've done the wrong thing or is litigious or something like that, and you don't have a file note, it can cause you a lot of grief, a lot of stress, a lot of wasted time. So always make sure that you've got a file note. Does that answer the question? I hope.
Sorry, I couldn't find the unmute button. Yes, Olivia says yes, thank you. I'm loving all the stories too, Jem.
Okay, no problem.
It would be good if they happened to you,
yes.
to you as a solicitor, though. But
they're all true.
Thanks for sharing.
Okay. Now, could I also, the next point I want to make is avoid confrontational letters. So be careful with your communication, particularly with other practitioners. Now, this has become particularly problematic with emails, because someone might send you an email. Perhaps they're being rude to you. You take offense to it. You blast out an email, send it. It gets seen by someone else. It's got something perhaps that is sort of defamatory. And trust me, solicitors do defame each other, say nasty things to each other. And before you know it, you've got the solicitors being defamed saying, I'm going to sue you for defamation. I'm not saying when I was at the professional indemnity insurer, it happened every day, but it happened regularly. People, at least, I can't recall an instance where they actually sued for defamation, but there were threats of defamation. And if someone threatens to sue you for defamation, it's scary, particularly when you're a junior practitioner, because you have to go into your boss and say, says they're going to sue me for defamation. I recall we had two practitioners that disliked each other intensely, and they were both in sort of personal injuries. So one used to act for defendant insurers, other used to act for plaintiffs. So they were often came into conflict or contact with each other because they were acting on either side of a matter. And they were always saying nasty things to each other. I remember one instance where one of the practitioners told us that the other practitioner was telling patients in some psychiatric hospital to contact them if they wanted legal advice. So he was getting all these phone calls from people in a psychiatric hospital, which didn't make him too happy, but they were threatening. They wanted to say something, then he'd say, I'm suing you for defamation. So the solicitor that was said he was going to be sued had to notify the professional indemnity insurer. Then the other one would say something, and then he'd have to notify the other solicitor, say he's going to sue him for defamation. So he'd have to notify the professional indemnity insurer. So this was going on all the time. So be careful. Could I suggest that if you're annoyed, be careful. Think twice before you press that send button. If it's, you're feeling annoyed, wait for sort of tempers to cool the next morning before you send that email, because you could be biting off a lot more than you can chew. Confirm instructions. We've really talked about that. Make sure you know what the client wants you to do. And then finally down the bottom, I've got there, avoid legalese and control the client interface. Solicitors sometimes get themselves into trouble because they don't use plain language. So they give a client advice, but the client doesn't understand it because they are not using plain language. So please, everybody, I'm sure that you've been told this 100 times. If you come to the College of Law and do PLT, you'll be told it 100 more. Always use plain language when you're talking to a client. You don't want a client to say, you never told me that, you never explained that, when in fact you did. You just did it in such a way that they couldn't understand it, and it results in a claim. I've got there, control the client interface. Now, what do I mean by that? A number of years ago, the New South Wales Professional Indemnity Insurer told us, when I was at the Queensland Professional Indemnity Insurer, that they had a whole bunch of claims which they were called the coffee shop claims. And the reason they were called the coffee shop claims is because they arose out of things that occurred at coffee shops, restaurants, nightclubs. Often clients, you become friendly with their solicitors. They, if it's an insurance company that's giving somebody work, you get to know them, you take them out to lunch, out to coffee, out to dinner. That's absolutely fine. But please, if you are going to do that, if you have advice that you want to give the client, or the client wants to give you instructions on a matter, do it before you go out, because it can be problematic if you don't. Why? One, if you're sitting at a coffee shop, everyone can overhear you, so there's no confidentiality. Two, you're probably not in a position to be making notes, which we've just discussed is very important. And three, if you're sitting at a nightclub or a loud place where music is playing, the client's probably only hearing half of what you're telling them if you're giving them advice, and you're probably only hearing half of the instructions you're being given. And there were, in New South Wales a number of years ago, quite a few claims that arose out of people that were, taking instructions while they were sitting at lunch, drinking alcohol or drinking cups of coffee and things like that. So if you want to take people out, by all means do, but please do business first at your office or their office, where you can sit in a quiet environment, make notes, and then go out and have coffee. Okay. Now, I'm just going to go through these quickly because I've just put this in. This is nothing that you can really do, but your workplace, and I'm sure most workplaces should have systems in place to avoid claims. So obviously, they should be doing things to make sure any conflicts are identified and managed. You don't want to find out partway through a matter that someone up the hallway is acting for the other party, or something like that. There should be regular file audits, so particularly for junior solicitors. So if there are any problems with files or things that might go wrong, or people are sitting on things because they don't know what they should be doing, that they are identified, and they are sorted out. And then time limits, they should always be recorded in several places, because missing time limits is a source of a lot of claims, particularly in things like personal injuries. Ensure that all staff are aware of how professional indemnity insurance works. That's very important. So that means everybody, including secretaries, paralegals, because they're all covered by the policies. And then finally, I've got there, ensure that files are stored in such a way that they can be easily retrieved should a claim be made. I was just telling you about that claim where the solicitor saw someone once, didn't see them for a number of years, but was still able to produce the file note. There's no point in having file notes if you can't find them, because you may need them 2, 3, 4 years later. So they have to have a way of storing all the files so that they are easily available should a claim come out of the woodwork in, 4 or 5 years' time. Now, I just want to talk in the very short time we've got left about professional indemnity insurance. I haven't gone into this in any detail because I know people are here from all around the country, and every policy will be slightly different, obviously. So there's no point in just talking about the Queensland policy or something, because that might not be of much interest to people in Victoria or Western Australia. But just be aware that if you are a solicitor in private practice, you will have professional indemnity insurance. And as I said a minute ago, you should become familiar with your policy of insurance. Now, generally speaking, so I'm just talking generally about policies of insurance, they cover you. So yeah, we have insurance because people, despite their best efforts, do make mistakes. So you have to have insurance. They will cover you for civil liability arising from the provision of legal services. That's what they usually cover you for. So what do I mean by civil liability? Things like negligence, things like defamation, breach of contract. So all those sorts of things you will be covered for under your policy of insurance, provided they arise from the provision of legal services. So if you've been negligent, it has to arise from the provision of legal services in the ordinary course of business. If you are, so you should be aware of that. If you are working at a firm, don't think that your policy of insurance will cover you if, for example, you are sort of flinging yourself around a nightclub at 3 o'clock in the morning and handing out legal advice to people, because that's not in the ordinary course of business. I know of another case where a young solicitor thought she was doing someone a favour. She was in practice, but she, in her own time, prepared a will for somebody. And I'm not exactly sure of what happened, but there was some pretty big mistakes in the will, and she was not covered by her professional indemnity insurance, because your employer is not going to cover you for work that you, as I said, for advice you're giving, in nightclubs or at the races or something like that, or things you're doing at your kitchen table, on a Sunday afternoon. So be very careful about handing out legal advice if it is not in the course of your employment. Now, different policies will have different exclusions, but just a couple here, which I think would be pretty common. It doesn't cover you for personal injury. So if your client comes into your office, trips on a rug and falls over, that would be your public liability policy that would respond, not your professional indemnity policy. Doesn't cover you for perhaps property damage that you might do. So let's say you spill a cup of coffee on someone and ruin their outfit. It's not going to cover you for that either. And obviously, it's not going to cover you for your dishonesty. So if you do something, there's a claim arises as a result of your dishonesty, then you are not going to be covered for that. So you've got to be very careful about that. Your obligations. You will find, if you look at your policy, and I encourage you to look at it and become familiar with it, there are certain obligations upon you, the solicitor. And one of the most important ones is that you have to notify your solicitor, your insurer, of a claim or circumstances that might give rise to a claim. Now, what do I mean by that? Well, a claim is pretty obvious. If someone perhaps serves you with proceedings and in it they say you're negligent, that's a claim. If someone writes to you and says your negligence has cost me $20,000, you've got to pay, I demand that you pay me $20,000, that's a claim. You should also notify your insurer if there are circumstances that give rise to a claim. For example, someone might have instructed you to commence proceedings for a personal injury matter before the limitation period expires. Let's say the limitation period expires today, and then you realise tomorrow, oh, you've forgotten to commence those proceedings. You know of circumstances that may give rise to a claim. The client doesn't even know about it, but you know. You should advise your professional indemnity insurer. So what I'm saying is, if you think you've done something wrong, and this is probably the second piece of advice I can give you. If you forget everything else, this is the second thing that you should really take away with you, apart from committing everything to writing, is tell somebody, notify them. There'll be someone in the firm that is responsible for any claims. As difficult as it is, things won't get better if you hide it. They always say it's not the crime, it's the cover-up, and that is true. So as difficult as it is, notify somebody that there might be a claim. Now, I don't know about other policies, but it could well be the case in those policies. Certainly in the Queensland policy, if you don't notify your insurer in a timely manner, they will still insure you, but you will be liable if the insurer suffers any prejudice. What do I mean by that? Well, what I mean is that if you, let's say, for example, it's a conveyancing matter, you're acting for the buyer, the contract is subject to finance, and the finance clause, so often you sign a contract, you've got 14 days within which to get finance, the buyer has, and when they get the finance, the buyer has to notify the seller, or the seller can terminate the contract. Let's say you forget to notify the seller. The seller terminates the contract because up until recently in this rising market, property prices are going crazy, and perhaps they want to put it back on the market and get even more money. So you forget to notify finance for your buyer, the seller terminates the contract. The buyer contacts you and says, because of your negligence, the seller's terminated the contract, they've sold the property to someone else. It's now going to cost me another because of, a couple of weeks have gone by, it's going to cost me another $10,000 to buy a similar property. So you should pay me $10,000. You get nervous, stuff that in your drawer, forget about it. 6 months go by, and the buyer says, well, prices have gone up so much, to buy another similar house, I need $60,000. The insurer is entitled to say, well, we will pay the $10,000 because you were notified of the claim of that time. And if you'd notified us, we could have settled it for $10,000. Because you've sat on it for 6 months, it's now another $50,000. You're going to be responsible for that. So it's very important that you notify your supervisor or whoever it is in the firm that handles these matters if you know of a claim, or even if the client's not aware of it, but you know of circumstances that may give rise to a claim. That's one of the most important things that you can do. And I see we are out of time, so I'm going to leave it there. I hope it's been useful. Has anyone got any questions to finish up?
We haven't, Jen, but
okay.
If anyone does have any questions, please pop them in the chat. I'm just keeping an eye on it. But that was very informative, and there are some crazy situations. I love the instruction to clone the children.
That is a true story. I swear to God, that is a true story. So yes, I always sort of chuckle about that. You never know what a client, now obviously that's ridiculous, but you never know what a client actually wants to get out of a matter unless you ask.
Dear, you do wonder what happens in the minds of some people, and I'm sure that's a bit of a crazy story from the coalface, so to speak. So thank you very much. I do love this little one last thing that will leave you: stay out of trouble. I love all the tips that you've given us tonight, Jen, some really, really practical advice. And I love the key takeaways to make the notes, to tell someone to don't shove it in your drawer and try and ignore it. It will not go away.
It will not go away. And there's a big temptation to do it, but you're better off. Someone told me once early in my legal career that there's real power in telling the truth, in marching in and saying, right, I've made a mistake. How are we going to fix it? So I think that's very important. And I think, you know, if you ever get into trouble, hopefully you won't. Honesty is always the best policy. Absolutely. And as officers of the court, we're probably bound by that criteria, but that's another conversation for another night. So thank you very much, Jen. There's some thank yous coming in from the audience. So thank you very much, everyone, for being with us this evening. I hope you've got a lot of sort of taken some great tips and notes away that Jen has shared, and certainly it will keep you out of trouble. So we'll sign off for the evening. Thank you again, Jen. Thank you for everyone joining us. And we look forward to seeing you at one of the next sessions, the last sessions tomorrow. So good night, everyone. Good luck, everyone. Thank you. Goodbye. Bye.